I'm also going to address one of the questions we received. This one comes from Louis. Louis asks, why do debt counsellors ignore section 81 sub 1 of the NCA? Louis, I think that's somewhat of a loaded question. I'm not certain that debt counsellors in general ignore any section of the Credit Act, but nonetheless, let's see how we can answer that. Section 81(1) is under the heading of Prevention of Reckless Credit, and it says the following. When applying for a credit agreement and while that application is being considered by the credit provider, the prospective consumer must fully and truthfully answer any requests for information made by the credit provider as part of the assessment required by this section. Now, first I must mention that it is an absolute defense against a claim of reckless credit or a charge of reckless credit if the consumer did not truthfully answer questions or provided correct or authentic information during the application process. And that is specifically provided for in terms of section 81 sub 4, which says, for all purposes of this act, it is a complete offence to an allegation that a credit agreement is reckless if the credit provider establishes that the consumer failed to fully and truthfully answer any requests for information made by the credit provider as part of the assessment required by this section. Now, it is incumbent upon all registrants in terms of the National Credit Act to comply with all the provisions of the National Credit Act which are applicable in the circumstances. The same goes for debt counsellors. There is no reason why a debt counsellor is permitted to simply ignore section 81 sub 1. And if I understand Louis' question correctly, he wants to know that when in circumstances where he can prove that a consumer was not truthful in terms of the credit application, and the consumer then applies for debt review, whether he can oppose the debt review application. Yes, Louis, you will be able to oppose the debt review application. You will also be able to ask for that credit agreement specifically to be excluded from the debt review application. But my advice always would be to consider the matter on a case-to-case basis. It may be to your benefit to rehabilitate the consumer, and at least in terms of the debt review process, you will receive some of your monies. But again, it depends on a whole variety of factors what you will do in each specific case. I hope this was helpful, and I hope that you have enjoyed this video with us. If you have any suggestions as to topics, if you have questions or queries, please forward them to Mycomax, and I will do my best to get around to answering all of them. And remember, this is your one and only opportunity to obtain very expensive legal advice from one of the top law firms in town for free.